Well, good morning, Chair and members.
Good morning.
I'm here today to present AB 2003, which will bring some common sense reforms to transparency to the unlawful detainer process. One of the most prevalent issues I hear from constituents from my district is the strain caused by lengthy unlawful detainer proceedings when a tenant stops paying rent. This problem hurts small business property owners disproportionately because they cannot afford the lost rental income when the process drags on over many, many months. My bill seeks to bring small improvements to the efficiency and transparency of the process while still preserving the due process rights of tenants. It has three main components which mainly focus on situations where property owners are not aware of the habitability complaints made by these tenants. AB 2003 asks tenants to specify if they've contacted the property owner or the respective local government if they allege habitability defense when answering the unlawful detainer complaint. This will provide important information before the case is heard in court. Landlords will become aware of the complaint and will be incentivized to repair the property as may be required. AB 2003 also allows property owners to inspect the property under certain conditions to address habitability issues when they are raised. Current law makes no provisions for the owners to inspect a property if a habitability complaint is made. Landlords will be required to follow existing law regarding notice to enter the actual homes. Since owners are legally responsible to provide habitability in a dwelling, they should be able to have access under limited conditions, and I emphasize that, to address these problems. Lastly, it does not allow the tenant or the landlord to switch court venues if the trial is closest to the property. 2015 statistics from Judicial Council show there has been a steady decline in the speed at which unlawful detainer cases have been resolved. When landlords experience expense and lengthy unlawful cases, it undermines the entire supply of affordable housing. This is because landlords are likely to be extremely hesitant to accept tenants who had ever struggled to meet their monthly rent after experiencing a lengthy unlawful detainer case. More importantly, when courts are flooded with high numbers of unlawful detainer cases, it undermines access to justice because the courts are clogged. Taking small steps as outlined in this bill will help owners and tenants work out habitability issues without needing to proceed with unlawful detainers. And it will also reserve the process for meritorious cases. With me today to provide testimony is Ron Kingston, who will utilize the time. I think they're going to divide it up, though. Mr. Carlson
First
and Mr.
witness,
Kingston.
please.
Thank you, Mr. Chairman. Ron Kingston, representing some regional apartment associations, the Apartment Association Southern California Cities, the Apartment Association Orange County, East Bay Rental Housing Association, and the North Valley Property Owners Association. This subject matter, unlawful detainers and evictions, has developed into some very significant changes, and these changes compels us to bring forth to you today what we view to be reasonable responses. They're not impossible. They're not difficult to comply with. They're very, very logical, and we want to explore with you each of these issues and explain so we thoroughly understand what is at issue and why we bring those to you. The first issue is this. In an unlawful detainer, when there is an answer, the tenant checks the box quite often that it is due to a habitability issue. Almost every case, we have hundreds of examples that the tenant has not completed that form. We have no idea what the issues are. It's not as if we can pick up a crystal ball and say, aha, in Unit 3, the problem is, and we can go out and repair it. What we find, on the other hand, is this. Once the answer is given to us, the court does proceed, will set the matter for trial, and demands are forthcoming. This is an issue that is not come forth when a tenant is self-representing or in pro per, if you will. This is an issue where there are multiple firms, and we have example after example. It doesn't make any difference if it's in the Bay Area, Los Angeles, or San Diego, where the completion of these forms and representation is by defense counsel. Some people will observe that we should file a complaint with the state bar. It's impractical based on what we believe is an appropriate fix as we will propose. So the first change we are asking for, which we view to be reasonable, is first the condition upon which the claim of habitability, it had to exist before, for example, our April 1st payment. It can't exist in the future. So the tenant would be given the clear information, whatever the complaint is, it had to exist, whether it's March 31st, March 15th, March 1, we don't care, as long as we know that the condition really did exist before the rent withholding and non-pay rent existed. We don't believe that is a very terrible burden. It has been pointed out that that's impossible. We submit that it's really reasonable. We just explain it. Point two.
I'm going to need to wrap up.
Okay. Thank you, Mr. Chair. The second issue is very, very important. Once we get this information, we would like to know if you've complained to the city, what department you have complained to. We've spent better part of 5 hours researching City of LA and the County of LA, trying to find out.
Mr. Kingston, I'm going to move to your next witness, please.
All right.
Mr. Chair and members, Steve Carlson for the Apartment Association of Greater Los Angeles and the Santa Barbara Rental Property Association. I'd like to put this issue maybe in a broader context. Our members are generally small business owners, 10 units or less. The thing we've heard over the last 3 or 4 years is we need to fix the unlawful detainer process. What we have been running into is, and this bill is a small step, we believe, toward dealing with that. The issue that has been most galling is that many of these private outfits that offer eviction defense services will be asking for jury trials in unlawful detainers. That is certainly not the intent of a statute where you're supposed to have 20 days to be able to regain possession of property. The landlord then is faced with, tens of thousands of dollars of costs. Courtrooms are clogged. It takes months to be able to get a courtroom. The defendant's lawyer comes back to the landlord's lawyer, and says, okay, I will waive the request for jury trial if. And generally, the demand is waive all back rent, let my person stay in there for a couple more months, seal the record, and pay me X thousands of dollars to the tenant and my attorney's fees. And the landlord's attorney has to look at the landlord and say, you're going to save money if you do it this way, and you're going to get your property back quicker. This is the overarching the reason that we're here on this bill, and we'll be here on other legislation going forward. It's something that needs to be fixed, and we need your help to try to fix it. Thank you.
Thank you. Other witnesses in support?
Mr. Chair and members, Pat Moran with Aaron Reed and Associates representing the San Diego County Apartment Association. I'm in support of the bill for reasons previously stated. Thank you.
Thank you.
Catherine Borg with the Western Manufactured Housing Communities in support.
Sean Topakian with the California Apartment Association in support.
Thank you. Anyone else in support? Seeing none, is there opposition?
Good morning, Mr. Chair. My name is Jith Meganathan, and I'm a policy advocate for the Western Center on Law and Poverty. We strongly oppose AB 2003. All we have is anecdotal evidence regarding isolated instances of the habitability defense being abused. We should not be making law on this basis. The reality is that according to Judicial Council, 90% of tenants in unlawful detainer proceedings are unrepresented. If false habitability claims are being made by an unrepresented tenant, any competent attorney should be able to demonstrate that fact. As for the 10% of tenants who are represented, Code of Civil Procedures Section 128.7 allows for the court to impose sanctions on an attorney who makes factual contentions that lack evidentiary support. Those sanctions are paid by the attorney, so the landlord doesn't need to worry about whether or not he or she can collect those funds from the tenant. As for the requirement that the tenant plead whether he or she has lodged a complaint with the landlord, doesn't the landlord already know this? This requirement appears designed to trip up unsuspecting tenants, either to get them to make binding admissions in the answer or else to perjure themselves. AB 2003 also restricts tenants' ability to seek a change of trial venue. We are of the view that the stringent requirements for obtaining a change of venue under existing law are sufficient. Any frivolous motion can, again, be dealt with through a motion for sanctions. Perhaps the worst part of this bill is the provision that would allow landlords to enter the home to make habitability inspections. This bill would completely gut tenants' privacy protections. Sexual harassment of tenants by property managers is an endemic problem in California. Right now, if a property manager unlawfully enters a unit, the tenant can seek a restraining order and sue for damages. But if this bill were enacted, the property manager could simply claim that he came in to inspect for vermin and escape liability, leaving the tenant completely vulnerable to harassment in her home. Existing law provides landlords the right to enter the property with the tenant's consent, to deal with emergencies, or to make repairs. These are sufficient. Please do not further erode tenants' privacy by passing this bill. Thank you.
Thank you.
Good morning, members, chairman and members. Brian Augusta on behalf of the California Rural Legal Assistance Foundation, also in opposition to this measure. Let me make a few quick points, building on what my colleague has said. Number one, the pleading requirements of this bill are unworkable. They would require the defendant, and as my colleague has said, largely in most cases unrepresented defendant, to plead elements of their defense that they're not required to prove at trial. So they're either not going to raise the defense, even though they may be entitled to assert it, and even though they may ultimately have a judgment in their favor in that regard, to plead elements that they're not required to prove. So they may not actually raise it. If they if they assert the defense without pleading these facts, they could be subject to a motion to strike. Conversely, as the analysis points out, there may be an argument that if they plead these facts, which aren't an element of the defense, they could be subject to a motion to strike. The reality is most plaintiffs are represented, most defendants are unrepresented, and this sets up yet another hurdle. Our clients, and I represented them in unlawful detainers, this is we heard about delay. This is a bewildering process for our clients. The summons is 5 days. If you get that on a Friday, that's 2 days that you don't have a chance to talk to anybody about your case before you have to file an answer. To put up these additional hurdles will close the door to meritorious claims regarding habitability. And I want to just make another point about the tenant privacy part of this. So the current law says that the landlord can enter the unit to make necessary or agreed upon repairs. They're going in to do something specific, something that the tenant has asked or that is known to need repair, and the repair is made. This bill would add a nebulous right of entry that's to comply with the habitability provisions in the code, which we fear will be routinely abused. Yes, they get advance notice, but they have no ability to say, that's not something that I need you to come in to do. So for all those reasons, we're very concerned that this bill further tilts the balance against unrepresented tenants, and we would urge a no vote.
Thank you. Next witness testimony.
Jeremy Hingson for the California Civil Liberties Advocacy. We are strongly opposed to this bill because we feel that it places an onus on the tenant, who is often a generalist, as opposed to the landlord, who should be a specialist in his property, and thus be able to provide more expertise. Thank you.
Thank you. Any other witnesses in opposition? Seeing none, I'm going to bring it back to the committee. Mr. Lackey, we've talked a little bit about this before, and I'm recommending a no vote, and I think for some specific reasons that on the barring an ability to change venue, I understand the frustration with the court system, but it's not because of the unlawful detainers. In fact, there are priorities in the court systems for unlawful detainers, and not being able to move venue, that we would be creating that almost uniquely for these kinds of cases, and I'm just not sure that's good. That's good policy. The other requirements that we're adding in this bill that you're seeking would heighten evidentiary requirements for a plaintiff in this case or for the tenant in this case, and again, those are really not precedented in other areas, and I'm concerned about heightening the pleading requirements for an individual class of folks as opposed to others. And I guess I understand the need to be able to enter the premises, but the way this is written, as we create this right of entry under this bill, I think it really does have some significant privacy implications on the potential tenant giving the landlord otherwise unfettered access. A tenant who's under an eviction notice is under a great deal of stress, probably in that situation and others that are going on. They're not necessarily very well equipped to be able to deal with and manage the situation. And there may be a long-standing habitability issue that they hadn't bothered or needed to raise. I don't want to do anything to be able to preclude that affirmative and appropriate defense ultimately in the way that tenant is allowed to do under state law. So I think this bill is problematic. We're best when we're with the legislature trying to essentially level playing fields, and I'm afraid that I believe that this bill tilts that playing field in the wrong direction, and for folks who are struggling to stay in the housing, for people who are really vulnerable, very vulnerable to the system around them, and that's why my no votes recommendation. Other questions, comments from members? Mr. Wagner.
A couple of things. First, as a legal matter, if there's a habitability issue that they haven't bothered or needed to raise, it is by definition not a habitability issue, because that's what habitability is about. You can't live there any longer, and you would have to raise it to, in fact, preserve the defense. So certainly that's not an argument against the bill. And I guess, secondly, if you would, Mr. Lackey, explain why you think it's important to put the venue change provision in this bill.
Yeah, the reason why, I could tell you that specifically in my district there has been some manipulation in the court process, whereas these venues have been assigned to the Los Angeles region, which is quite a distance from our location. It's over an hour when there's not traffic, and it makes it very, very difficult for the property owners to actually attend those particular proceedings.
Mm-hmm. Does it have any impact on the tenants?
It would also, clearly have impact on the tenants, because they would have to find a way to transport themselves down into that region, and it's costly.
Okay. Now, I guess on the issue of habitability, there are lots of examples in the law where if you raise an issue in defense, an important right is waived. For example, if you make a claim against your attorney-client confidence, which is, it is sacrosanct, much more so, frankly, even than privacy in our law, it's waived. What's the objection to, for the opponents, to you've got a tenant raising a habitability claim to allowing the landlord to come in and inspect, determine whether indeed that habitability claim is legitimate, to find out what defenses the tenant might have, the landlord might have to those habitability claims, because you're the one who's put that in issue. What's wrong with allowing the landlord to protect themselves?
Yes, sir. So that situation would be covered by existing discovery provisions in the Code of Civil Procedure. What this bill talks about is allowing pre-lawsuit inspections, and that's what we feel would create an enormous loophole in the existing privacy protections for tenants that could be abused in a number of ways.
But isn't that when we need the evidence, is pre, not after the case is filed and somebody's gone about making changes, good or bad, to their property? Isn't it allowing for a snapshot in time to determine whether in fact there's anything here or not?
Mm-hmm. The answer that the tenant has to plead requires the tenant to allege the conditions of the premises at the time the lawsuit is filed, which is 5 days after it's filed. There's then immediately provision for the landlord to conduct discovery into the status of the premises. So there is no time lag in which the situation could change. That's why we have a summary proceeding for unlawful detainers.
Thank you. Mr. Gallagher?
Yeah, I think there's a lot of talk here about this bill that has really nothing to do with the intent here and the actual language of the bill. Nothing in this is going to stop someone who has a legitimate habitability claim from raising that defense. All this says is that when they do so, that they have to just say in the pleading, did you inform the landlord, which is really the point. You're supposed to inform the landlord if you have a habitability issue so that the landlord can respond and do something about it. And if you can't make that very simple pleading, I think you have a problem with your defense. So legitimate habitability claims, this isn't going to stop those at all. But those who really don't have a legitimate claim, yeah, it will stop them because they won't be able to lie in a pleading. Otherwise, they're going to face some problems. They're going to have to be truthful about how they dealt with that habitability issue. Anybody who's been around unlawful detainer proceedings, and a lot of us have been, know it's a very general pattern. It happens a lot. Someone comes in with a 3-day notice to quit because somebody hasn't paid rent, or even a 30 to 60-day notice to, and at that time there's a claim made that there's been a habitability issue. And then this thing drags out for 3-4 months. Meanwhile, rent is still not being paid. And eventually it's determined that, yeah, there really is no habitability claim. And generally what happens, there's a settlement. Someone pays money so the person moves out. That's what happens. Okay, that's the reality. And it is abused a lot. Now, there are real, genuine, legitimate habitability claims. And when those occur, those are proven. And there is a sanction as a result of that against the landlord. So again, no legitimate habitability claim is going to get impeded by this legislation, by this law. And furthermore, to me, this actually helps tenants because it's going to put the landlord on the spot. Hey, if you don't respond to an issue, guess what? It's going to be on you to do this. And it also encourages them to respond to legitimate habitability issues. So to me, these are very minor changes. There's no groundbreaking substantive thing that's going to affect people's rights. It's just being consistent with what a habitability defense is all about. And I think these are reasonable, very minor changes to the pleadings, and I would ask members to really consider supporting this measure. I think it's a good measure both for landlords and tenants. So that's my 2 cents, and I'd be happy to hear any response about. I mean, does this not require landlords to be responsive by putting this in law? Isn't this going to require landlords to be more responsive? I mean, I'd like to hear just some comment on that.
Who are you asking that of?
I mean, either the author or some of the opponents.
Well, clearly that's the intention of this bill, is to resolve conflict, and if there is an inhabitability issue, it needs to be resolved before it goes to court, or at least after this situation becomes evident to the owner that there needs to be some kind of reasonable mitigation so that inhabitability no longer continues. And so the intention here is also to mutually benefit both the owner and the person, the tenant in the actual apartment. And we believe that this level of transparency facilitates that and allows for a more meaningful communication so that we can have mitigation, and that is clearly the intent.
Opponents, you were also asking
Thank you, Mr. Chairman. Let me just say, Mr. Gallagher, I think the one point on which I would disagree with your analysis is that the implied warranty of habitability, which is what is the subject of this bill, which was established by the Green versus Superior Court case, does not require the element of notice. The landlord is required at all times to maintain the premises in a habitable condition, and so it's not asserting that defense is not premised on notice to the landlord from the tenant, and that's the objection we have with requiring it to be pled in that manner. We would agree that in the general course of things, it is a good practice to tell your landlord when there are problems that need to be repaired, and we would encourage our clients to do such a thing. But the unfortunate reality, and we're not talking about the good landlords, we're talking about the bad landlords. My rural clients farm workers who live in deplorable conditions and are subject to forms of intimidation that would discourage them from making these complaints because they're happy to be paying market rents for cruddy conditions. But when it comes to an adversarial process in court and they're having to defend themselves, we want to maintain their ability to assert legitimate defenses. And that's, I think, where we part ways with what the author is proposing here.
Other questions, comments? Mr. Lackey, you may close.
Yeah, with all due respect, I think that this bill takes minor steps, very minor steps, to improve the unlawful detainer process so tenants actually remain protected, and it also helps improve the ability for the tenant and the landlord to communicate to mitigate potential problems. And I would clearly ask for an aye vote, and we would be more than willing to take amendments to try to get some reasonable negotiation, like the court venue issue. If that causes real consternation, we would be more than happy to amend that. But this is a very, very serious statewide issue that needs some kind of intervention, and we ask for your support.
Thank you. My recommended is a no vote. We still don't have a motion on this. So we do have a motion and a second. Call the roll.
Stone?
No.
Stone, no. Wagner?
Aye.
Wagner, aye. Alejo? Chow? Chu?
No.
Chu, no. Gallagher?
Aye.
Gallagher, aye. Weber? Holden? Holden, no. Mainshine? Ting? No. Ting, no.
So it's 2-4. The bill is on call.
Thank you.
We have, next is Mr. Bonta, item number 5, AB 2498.